Good evening to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss regarding the externment powers under the preventive detention. Normally, externment should be used as the last resort for the offenders who are dangerous to the society, as externment is against to the freedom of free movement which is guaranteed by the Constitution. This has to be applied in mind and test of reasonability should be there. This is what is emphasized by Bombay High Court. Ultimately, the matter has come to the Supreme Court. Now Supreme Court has given a clear-cut direction in this regard. While disposing the case of Deepak, son of Laxman Dogre, versus State of Maharashtra in Criminal Appeal number 139 by 2022 on 28th January 2022, two judges bench of the Honorable Supreme Court of India, Justice Ajay Rastogi and Abhay S. Voka. You may be knowing Abhay S. Voka. He previously worked as the Chief Justice of Karnataka State till recently, and now he is elevated to the Supreme Court. They clearly stated that the externment, act of externment, should be resorted to sparingly, and it should be an extraordinary means. Right? This is what the Supreme Court held. Now we'll go to the case facts. Mr. Deepak, he has been arraigned as accused in 5 cases, like crime number 36 by 2013 under section 452, 354 and 504 IPC. That is trespassing into a house during daytime and outraging the modesty of a woman and intentionally insulting her. Of course, the case ended in acquittal. Then he is also concerned in crime number 214 by 18, 247 by 18 under section 354A IPC. So it is pending outraging modesty. Once again, crime number 317 by 18 under section 307. This is more dangerous. This is nothing but an attempt to commit murder. Almost murder case, just like murder case. It is just an attempt to murder. So in all these cases, he was arraigned as an accused, and therefore on 15/12/2020, the competent authority, they have given an externment notice to him, stating that he should move away from Jalna district for 2 years. He will be externed from Jalna for 2 years. So this order should come and it should be executed within 5 days. So the police, using their powers under section 56 of the Maharashtra Police Act 1951, they have given these orders. So what are the grounds we have to know? So the grounds stated by the competent authority is that his activities are very dangerous to the society, and the offences are grave and serious in nature, and they are likely to cause a disturbance to the public peace and tranquility. This is the routine work. We might have seen hundreds of cases like this. Right, then after taking the notice, of course, he has approached the Honorable High Court of Maharashtra. There his petition was dismissed. It was not taken into consideration. Ultimately, he has to tap the doors of the Honorable Supreme Court of India. Now Supreme Court has observed, because it's a constitutional court, it has observed in the points of Article 19A. You may be knowing Article 19A, 19D, I think. It shows a right to movement, right to freedom of movement. So he can move to any place, he can stay at any place, right of place of residence. All these things are there in Article 19. So, but at the same time, Article 19 Clause 2, it says about the reasonable restrictions, test of reasonability. So, state can make any law regarding the externment procedure. Therefore, this was it. But please remember, before passing orders under section 56 of the Maharashtra Police Act, So there must be an objective material to the subjective satisfaction of the competent authority. The material should be objective. Merely involvement in these cases is not sufficient. If his activities have caused the disturbance of the public peace, so when he attempted to commit the murder, the entire area, they have closed their shops, the tradesmen shuttered them down and ran away, and for the 1 or 2 days the shops were not open. That is an indication that public peace was simply because there were disputes, he might have gone and attempted to kill him. So the competent authority, of course, it need not write all the judgment like all these particulars, but at least it must show the application of mind. So therefore, in this case, the High Court has not applied its mind perfectly. It is apparent on the face of record, right? Of course, the advocate on behalf of this Deepak, son of Laxman Dogre, argued that at the instance of local MA, I think Kuchu or somebody, Narayan Kuche, MLA, the case was foisted against him for taking out, for wrecking the personal grievances. Of course, Narayan Kuche was the relative of the appellant, that is Deepak also, right? So since there are family disputes between them, he wanted to settle the family disputes by implicating him in so many cases. So this is the background. Of course, the advocate might have convinced the Supreme Court. Here two things are important. Mere involvement in cases does not say that his presence or his activities are dangerous to the society. This happened in the year 1985 when we arrested Mr. Kathipadma Rao. Of course, now he is, I think he got some award also. Kathipadma Rao, and under preventive detention, the review committee of the AP High Court, they have put the same questions. Inform us whether he is convicted in any one case or not. After all, so many cases of 153A, all these things have been booked against him. Whether he is convicted in any one case or not, no. Whether there are any previous incidents or previous antecedents of involving in murder or things, no. Then, simply because saying that he is involved in hundreds of cases, it is not suffice. Release him. Same thing happened in the case of Kathipadma in the year 1985. That is in relation to the Karanchedi carnage which occurred in 1985. Secondly, please remember, in a particular case, the case in which it was acquitted, the victim, that is Varsha Bhaskar, she admitted that the brother of MLA advised her to make calls to him. So it is nothing but inducement. So definitely, purposefully, intentionally, they have involved him in these cases. You may be knowing that Vallabhaneni Vamshi or somebody MLA, P.S.R. Anjaneyar, when he was the commissioner, same tamasha has gone. Ultimately, P.S.R. Anjaneyar, I think he was transferred. So there are certain people, I think Vallabhaneni Vamshi was also MLA at that particular time. I don't know whether for Gannavaram or something. There is a story, like similar story happened in Vijayawada. So such things do happen. So therefore, Supreme Court in its wisdom stated that the Honorable High Court has not applied its mind properly, which is evident, apparent on the face of record itself. Ultimately, the externment orders given by the competent authority, that is maybe Commissioner of Police or Collector, they are definitely quashed and appeal is allowed. So, Supreme Court gives that much of value for the constitutional right, fundamental rights. This is what I want to say. So, if any police officer sees this, please remember, the court will not appreciate mere involvement of cases. Only thing is, either he should be convicted or the circumstances should be so forced that there is a disturbance to the public order and peace and tranquility. Law and order is different from public order. We will discuss on a separate issue. Anyway, it's getting 10 minutes time. So, I will stop here. So, this case, please read it as Deepak, son of Laxman Dogre versus State of Maharashtra. You can see it in Live Law 2022, SC, page number 93, decided by Justices Ajay Rastogi and Abhay S. Voka. Thank you very much.